Welcome to another episode of Legal Dilemmas, where you will find clear, concise legal advice. Today's topic is around whether an ex-partner can claim inheritance. So, my name's Safina.
And my name is Brenda.
So Brenda, I'm going to read out a question that I've received. My estranged husband has moved out of the family home after having an affair. I have now come into a substantial inheritance following the passing of my parent. I want to know whether my ex can make a claim against my inheritance.
Okay, now in general terms, I'm going to reply in general terms first. There is case law for an inheritance to be ring-fenced, and there is also case law for inheritance to be included in the matrimonial pot. That's just the general answer. So there is no clear answer that's generic for everybody. It depends on the individual circumstances of the case. Now, I'm assuming she doesn't want to give him a penny,
No.
in which case he will be forced to issue an application at court. She won't want to mediate the issue. And if he issues an application at court, the court will want a declaration of all assets. So she will have to declare, when she declares the matrimonial pot, all the assets of husband and wife, and then the inheritance will also have to be declared. Now, it is considered to be an asset, but it does not mean it will be handed over to him.
Right.
But it will be considered as an asset to satisfy current and future needs. So it could be that he receives a greater share of the matrimonial home and she keeps her inheritance.
What sort of factors will the court look at in making their assessment?
Okay, so they will look at first both the income of both parties, the ages of both parties and the children. They will also look at his contributions to the marriage prior to him having an affair in terms of financial contributions. And if it means that she can have her housing needs met by having a smaller share of the family home, then the court will look to that because it will mean both parties will be rehoused. They certainly won't say to her, oh, give him £200,000 so he can buy a house, but they will tell her to use some of that money to perhaps satisfy her own needs so he can have something extra from the other assets that are family assets. So the answer is not clear-cut. It's based on individual cases and the Section 25 factors, which are the income of the parties, the ages of the parties, the ages of the children, any disability, the housing needs, all those factors will still apply.
That's really helpful. I mean, we don't know, she hasn't actually put in the information whether they've got any children. But obviously you're right, the court will need to factor in the needs of the children depending upon their age. So I suppose in a summary, the court will need to undertake an assessment in accordance with the Section 25 factors, looking at needs, income, age, sharing, resources, etc. And then come to a decision. Hopefully the parties will be able to come to a decision themselves by way of consent through negotiation, although it doesn't sound like this individual is particularly happy about the fact that he's actually had an affair, and you know, that's left her feeling quite upset.
Sorry, one point, the fact that he's had an affair is not relevant. So that is conduct, and it won't really be taken into account when looking at how the inheritance or the matrimonial assets should be divided.
Yeah, and I think it's really important that you flag that up, Brenda, because I think there is a misconception that just because someone's been adulterous or behaved inappropriately during a marriage, that they should be financially shortchanged in some way. So thank you for flagging that up. So on that note, thank you very much for listening. Hopefully you found this content really useful. Please like, subscribe, share, and make sure you have your notifications on for other videos.